Have you heard about the latest news updates for immigration for September of 2023? There's a lot of them to unpack, a lot of new stuff, including changes on in-person appointments at immigration, 60-day grace period for non-immigrant visas, new filing locations for you and VAWA, and much, much more. Stick around, we got a lot to unpack. Alrighty, so the latest good news is for in-person appointments. Previously, you had to dial in a number. It took forever to get an in-person appointment down at your local field office. Why would you want to do that, right? You want to do it so you can get green card stamps in your passport. If you were approved in immigration court and get your green card from your grant of the cancellation of removal or suspension of deportation, whatever the case may be, or adjustment of status in front of the judge, you want to finalize the process so that your green card can be made, you got to make an appointment to go down. If you have an emergency advance parole, you have to go down to the local office. Clarification finally issued. There is a new form. I put a link in the description box below. Check it out. You go complete it. Much more efficient to get your in-person appointment down at the local office. Newest news on the visa bulletin. This is huge, folks. There is a proposed change in the way that the visa bulletin is going to be issued. If you look at the visa bulletin, you have family and you have employment-based time frames that you look at when you're looking at the visa bulletin. Filing dates, which are the second boxes, those are the dates where you can file your adjustment of status or start your MVC or consular processing procedures, okay? So what the proposed plan is that all of the dates in the filing section to be current. That is huge, folks. So what would happen basically is that whenever you get your I-140 or I-130, your petitions approved for family-based or employment-based, you can file your adjustment, remain in the U.S. until it becomes current on the final action dates. This is huge, good proposed change, may happen, may help a lot of Indians and Chinese applicants who maintain non-immigrant status and they want to change from the non-immigrant to the immigrant status. Good stuff, folks. All right, USCIS finally clarifies the 60-day grace period. What happens when you're on a non-immigrant visa and you're terminated from employment? When does that 60-day grace period where you can remain legal in the U.S., you can even change to another status, a B1 to get your personal effects in order, or to extend your non-immigrant status. If you're in H status, you're terminated, 60-day grace period. Within that period, you can transfer your H1 to the new employer. This is huge. So USCIS has finally clarified when does the 60-day period commence. The 60-day period commences when you get your last paycheck, all right? So you could be terminated on X date. If your last paycheck comes 30 days after, let's say, that's when the 60-day grace period commences. So the rule is 60-day grace period starts on your last paycheck or when your underlying visa expires, whichever comes first. That little note at the end, you got to make sure that you're aware that it could be that as well, all right? All right, some important news here. Those of you who have an approved U or an approved VAWA, you file then your adjustment of status. You have to know the new locations. They have changed the location. You don't want to wait 6 months and your case is rejected, right? So what I've done, I've put a link in the description box below. Here are the new filing locations for the U visa and VAWA applicants, all right? Just so you know, just giving it to you straight. All right, new policy on public charge. If you've received any type of public cash assistance, etc., you could be subject to a grant of inadmissibility. Now, there has been confusion on questions on the I-485. That's the application you file in connection with your adjustment of status. So there is a question 8 that has a bunch of public charge questions. The first question is, are you subject to public charge? That is not, are you likely to become a public charge? That's a whole separate question. If you answer that question incorrectly, immigration used to deny your case. Now the policy is that if for some reason in good faith you don't answer it correctly and it's found out that you did have some public assistance, there's going to be a request for evidence. They will issue an RFE. They will not deny the case. All right, then you provide the information that they request. Immigration then has discretion to approve the case. All right, YouTube family and GN subs, thanks so much for watching GrayLaw TV. Go to my playlist, great content. Go to the frequently asked questions Really good stuff, linking your most asked questions in the comment section to a video. Very good stuff. And thanks again. We'll see you next time.